When you file for bankruptcy, all of your assets are given to the bankruptcy estate. And that's for both bankruptcies. Now, in a Chapter 7, the Chapter 7 trustee will actually attempt to sell your house to pay off your creditors. And your house, by the way, is part of the bankruptcy estate. So, sometimes clients will say, I didn't intend my house to be part of the bankruptcy estate. Well, it is. But the trustee cannot sell your house if there's no equity in the house or if it's exempt under state law. One of the biggest protections for your house is a form of ownership that only married persons have, and that's called tenants by the entireties. And that's where you and your spouse take title to the house together. And the deed itself must say that you were married. It doesn't necessarily have to say tenants by the entireties with common law right of survivorship. Those are the key terms. But it must say that you're married and you're taking it as a married couple, something along those lines. Why do I say this? You would not believe the number of times that real estate in the Commonwealth is mistitled. Every Chapter 7 bankruptcy where there's equity, we automatically order a title search into the deed to your property. And what we are looking for in particular is the deed by which you and your spouse took title. Frequently in Virginia, the deeds will say joint tenants or tenants in common, and unfortunately when the deed does not provide that kind of protection, then you don't have it. And so sometimes we don't file cases for clients because we tell them if we file the case, you might lose the asset. It's not a guarantee. We can't guarantee necessarily what the trustee does in all instances, but we can tell you, in this case, I would not file. It's 99% certain he will administer the asset. So that's why we always conduct a title search of your house to determine whether we think you should file or not. Also with houses, we conduct a title search for a different reason, and that is, particularly in the Fredericksburg area, a lot of clients will have judgment liens recorded against their real estate. And I have some sad stories to tell you about judgment liens. Recently I had a client who had a repo of a car 10 years ago with Ford Motor Credit. The interest rate was 21%. He didn't know that they had taken a judgment against him, and he didn't know that they had recorded the judgment against his house. So when originally he owed $10,000, the judgment was recorded against his house. It had an interest rate of 21%. He now owes $50,000. And what's sad about that is he continued to pay his mortgage. His house continued to accrue equity in it, but it did not benefit him. It only benefited his creditors. So we attempt to get a title search in any bankruptcy, and the reason we're doing that is we're looking for judgment liens. You can strip them down in a 13, you can strip them off in a 13, and you can also strip them off in a Chapter 7. Now those are separate. In a Chapter 13, it's holistic, we do everything. In the case of a Chapter 7, the strip off or strip down is an extra that we do on your behalf. But it would be very nice for you to know that you actually have a judgment lien against your house and have some effort to take that lien off, and not be like the poor individual that I was speaking of, who unbeknownst to him had a judgment lien on his house for all those years that was gaining interest at 21% and literally ate his equity alive, even though he religiously paid his mortgage every month. In the 7, if there's no equity in the house, if the property is titled the correct way, the trustee will simply abandon the house and give it back to you. Now let me talk for a minute about the treatment of a house in a Chapter 13, because they're different. In a Chapter 13, perhaps you had equity in the house, and maybe that equity was available to your creditors. So instead of filing that as a Chapter 7, we file the case as a Chapter 13, and you pay back to your creditors what they otherwise would have received in a Chapter 7. And that way you get to keep your house and you pay your debts. In a Chapter 13, if you have 2 mortgages on your house and the second mortgage is not secured by any value. In other words, the house is underwater. The mortgage exceeds the fair market value of the house. The first mortgage exceeds the fair market value of the house. In that case, you can literally strip the second mortgage from the house. There's no second mortgage at all when you complete your Chapter 13 plan. So that's the situation with mortgages. There are a few other wrinkles that I'm aware of, but generally the long and short of it is, if I thought you were going to lose your house, I would have told you that. If I thought you were going to lose your house, I wouldn't have had you file for bankruptcy at all, or I certainly would have informed you of the risks. So that's why, when you have a house, we sort of give extra attention to your bankruptcy schedules.